Major breaking news out of the Northern District of West Virginia. A federal district court judge has just declared a major gun control law enforced by the ATF to be unconstitutional under the Second Amendment. That's right, a major win for the Second Amendment today. Federal court, West Virginia, Brown versus ATF. Stay tuned. We're going to break down this big win in 1 minute. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and a nominee for 2 separate Gundy Awards for 2024, the Male Influencer of the Year, and the top voice of the Second Amendment. I'm proud and honored to have received both nominations. All right, folks, huge news. The United States District Court for the Northern District of West Virginia, Judge Thomas Kleeh, the chief judge there, in an opinion today, has found that a federal gun control law that prevents 18 to 20-year-olds from acquiring firearms such as handguns, specifically handguns, under federal law is unconstitutional under the Second Amendment. Specifically, Judge Kleeh does a great job following the methodology that we've talked about on this channel, the Four Boxes Diner, also articulated, of course, by Heller and Bruin, and by the recent decision by the United States Court of Appeals for the Fourth Circuit out of Maryland that lays out the methodology for interpreting the Second Amendment, which, of course, is you start with the text of the Second Amendment. Now, we're going to get a little nuanced here because the text of the Second Amendment says, the right of the people to keep and to bear arms shall not be infringed. Now, this case here, the Brown versus the BATF, and I should note this is also the other plaintiffs involved in this case are the Second Amendment Foundation. So congratulations to the Second Amendment Foundation. And also congratulations to the West Virginia Citizens Defense League, another plaintiff in this case, as well as the 2 individual plaintiffs, Stephen Robert Brown and Benjamin Weakley. Congratulations to all of them on this big win against Merrick Garland and the ATF. So, you start with the text of the Second Amendment, the right of the people to keep and bear arms shall not be infringed. What's interesting, of course, is that there's no reference to buying or acquiring guns in that text on its face, if you want to be very specific in some ways. But it doesn't matter, because it's not really true in the following way. The word infringed means anything that will destroy the right or which provides a hindrance or an obstacle. So obviously, in order to be able to bear or to keep arms, the right of the people to keep, which means to possess, the right of the people to bear, which means to carry arms, requires that you first procure them in some way. And there's a couple different ways to procure them. You can make them yourself, or you can do what most people do, which is to buy them, to acquire them that way. So this is very good because textually, Judge Kleeh said that the right to purchase a firearm is a protected arm because it's necessarily implicated or necessarily implied, and thus purchase restrictions, meaning obstacles, hindrances, or destructions or whatever, any government law or regulation that infringes upon or hinders the ability to acquire, meaning the ability to keep and bear arms, is necessarily implicated in the text of the Second Amendment, which is exactly what we talked about on this channel before. And what the judge does here, Judge Kleeh does, is he relies on that recent victory and Maryland Shall Issue, the organization Maryland Shall Issue. I got to give them great credit. They're on a big winning streak lately. But Maryland Shall Issue, the organization out of Maryland, great organization, their big victory just last week or so in the United States Court of Appeals for the Fourth Circuit, dealing with knocking out the handgun qualification license, has borne fruit here in Brown versus BATF. Remember how I've tried to educate you, to teach you that every win involving the Second Amendment gives rise to other wins, because today's win in West Virginia will give rise to a judge in, let's say, New York, relying on this decision to win for the Second Amendment in New York. And those decisions today in West Virginia, maybe next week in New York, will be used to win for the Second Amendment like in Arkansas. So as I've always tried to teach you, that every one of these little wins is a major win when you look at how it ripples out and sets precedents that can be relied upon by future judges. Here is an example of what I'm talking about. So last week or so, the United States Court of Appeals for the Fourth Circuit, in the Maryland Shall Issue case, lays out and knocks out the handgun qualification license for Maryland, following the text first, burden shifts to the government, and the government bears the burden to do what? You know, the government bears the burden to come forth with historical analog laws at the time of our founding around 1791, when the Second Amendment was adopted to justify the modern-day gun control law. And if they fail to do that, meaning the government fails to meet its burden, they lose. And that's exactly what happened here with Judge Kleeh. Again, once he finds that the text of the Second Amendment is implicated, by virtue of the fact that the inability of a 18 to 20-year-old to be able to acquire guns, and that's what this case is about, 18 to 20-year-old young adults being able to acquire guns from an FFL, regulated by the ATF, that constitutes a hindrance on the right to keep and bear arms, and thus an infringement. And Judge Kleeh here, in making this argument, relies, among other things, on that United States Court of Appeals case for the Fourth Circuit issued by, or in that case of Maryland shall issue. Do you see how the Maryland shall issue when involving handgun qualification licenses now gives rise to a victory for young adults, 18 to 20-year-olds who want to be able to acquire handguns from FFLs against the ATF. Those precedents is how they roll up and start a small snowball, and it builds into an avalanche. That's the goal. So when I put in my thumbnail, because some of you make comments about this, if I put in my thumbnail, it's a major win or a huge win. It is. It is. Because of the implications of it. Even if you may say, hey, this is just a district court in West Virginia. No, it's much more than that. It's a federal judge in the federal system, a decision issued by that judge that can be relied upon in the future. So often, things that may not appear to be huge wins really are. And that's why I try to be very precise about what I'm saying. And this is an example of this. So the Maryland shall issue victory gave rise to today's victory in Brown versus BATF, because Judge Kleeh, among other things, relies on that in his big decision today. Now let's carry on. He then goes on and asks the question of, well, who are the people? As in the right of the people to keep and bear arms. Well, as I've explained before, as articulated by the U.S. Supreme Court in, for example, Heller, the people is a phrase that was written into several amendments by the Founding Fathers. You see the word the people, or the words the people, in the First Amendment, dealing with free speech. You see the people referenced in the Second Amendment. You see the people referenced in the Fourth Amendment, dealing with, among other things, unreasonable searches and seizures in criminal process. We know from all those other cases, interpreting the other aspects of the Constitution and the Bill of Rights, and including Heller, that the people means all American citizens, and maybe even more, but set that issue aside. All American citizens, all those people that have a common, continuous connection with our United States of America, which obviously includes American citizens. So here, Judge Kleeh says, in light of that definition, it's pretty clear that 18 to 20-year-olds are part of the people, because as a matter of the plain text, i.e. the right of the people to keep their arms, they are clearly Americans. So thus, textually, we have the right of the people, including 18 to 20-year-olds, which is what's at issue here. They're part of the textual people. Shall not be infringed. Infringe means to hinder. A inability of the people to acquire handguns from an FFL impacts or restricts or hinders their ability to get handguns in violation of the Second Amendment. So textually, we have an infringement of the right to keep and bear arms of the people. Now, what does this mean? You know what this means. The burden shifts, and Judge Kleeh shifts the burden to the government, just like in a criminal case where the burden of proof is on the government to prove that you're a criminal beyond a reasonable doubt. Here, the burden shifts to the government to say, okay, the text is satisfied. Now you show us a historical analog law that indicates that 18 to 20-year-olds are not allowed to acquire handguns or any kind of guns. And guess what happens? We know what happens. There's simply no historical analogs in the least that suggests that any time during the founding that 18 to 20-year-olds were not able to acquire handguns or any kind of firearms for that matter. The law was very clear. In fact, the lack of law speaks volumes, and this is the key. The anti-gunners are upset that they can't prove laws, but it makes a lot of sense in the following sense. You have a group of people here at the time of the founding that adopted the right of the people to keep and bear arms in the Second Amendment, right? So why would anyone think that those exact same people that adopted the Second Amendment as part of a fundamental right of our constitutional government, why would anybody think that they would be enacting all sorts of gun control laws that would restrict or hinder or destroy a constitutional right, a fundamental right that pre-existed the Constitution itself? Obviously, if you look at the history, specifically the actual laws on the books at the time of the founding, you find very few gun control laws. And that makes a lot of sense because the most important historical document of them all is the text of the Constitution itself. The Constitution is the ultimate historical document. about what the Founding Fathers thought was important and how things should be structured in our American constitutional form of government. So obviously when the anti-gunners are looking at the time of our founding in 1791 or so to try to find gun control laws to justify modern-day gun control laws, they don't find that many. It upsets them. It upsets them because they want to be able to restrict our rights. But they're simply not allowed to do so. And I'm happy to report here that Judge Thomas Kleeh recognized all of what I just said and said that it's quite simple that the government is simply not able to carry its historical burden because there are simply no similar restrictions in any respect during the founding era or the early Republic of the United States to justify this modern-day gun control law of 18 to 20-year-olds not being able to acquire handguns from an FFL or anything like that. Now, here at the Four Boxes Diner, I've always pointed out to you that 18 and 20-year-olds are clearly going to have the right to keep and bear arms. I don't see any real way for the government to get around that if you're honest about it. The Supreme Court deals with this case. And Judge Kleeh, I think, agrees with me entirely on this because he points out, in addition to the fact that there are no laws at the time of the founding that prevented 18 to 20-year-olds or young adults from being able to acquire arms. If anything, the historical record affirmatively disproves the suggestion by simply looking at what we've talked a lot. And you know, if you watch the Four Boxes Diner, because I've made you the smartest people in the room, and I don't care who else is in that room, I will make you smarter than them. I don't care what their credentials are. I don't care their Ivy League degrees. I don't care where they're from. I will make you smarter than them on this topic. And yes, I know it's a big debate about what happens if there's two fans of the Four Boxes Diner in the same room who's smarter. I would say you're equally smart. Okay, but with that said, guess where Judge Kleeh goes? He goes exactly where the Four Boxes Diner teaches everyone to go to, which is the Militia Act of 1792. The Second Amendment was adopted and ratified and went into effect 1791. 1792, a year later, if not even a year, the Congress, the United States Congress, including the Founding Fathers, of course, adopted the Militia Act of 1792. And the reason why the adoption of the Militia Act of 1792 is so important for this question about 18 to 20-year-olds being able to have a right to keep and bear arms like every other American is that it points out specifically that 18 to 20-year-olds were included in the definition of the militia. The reason why that's important is to be part of the militia required that you go out and get your own gun, your privately owned gun, your privately owned ammunition, your privately owned cartridges, your privately owned pouches, your privately owned black powder, gunpowder. That was on you to use your money, your resources to privately acquire it. So how is it conceivably possible that 18 to 20-year-olds, as part of being part of the federal militia under the U.S. Under the Militia Act of 1792, how is it possible that they would be able to satisfy their militia duties if they could not acquire all these items and objects and firearms in their private capacity as private American citizens to have on their farms, to have in their homes, to have in their, whatever, their units, their kind of their quasi apartments, if you want to call that, in their homes in Boston and so on. Obviously, they had the right to keep and bear arms at the age of 18 to 20 and then onwards. Because otherwise, why does the Militia Act say that 18 to 20-year-olds, among others, it goes up to 45, by the way, have an obligation to bring their privately owned firearms to them to the militia musters? And that's exactly what Judge Kleeh says here. Judge Kleeh says, I'm going to quote his opinion, in 1792, the United States Congress specified that each and every free, able-bodied white male citizen of the respective states resident therein who is or shall be of the age of 18 years old and under the age of 45 years, shall severally and respectively be enrolled in the militia. Judge Kleeh goes on to quote, indeed, the Militia Act further required every member of the militia to provide himself with a good musket or firelock, or with a good rifle. Over the next few years, every state revised its existing militia laws to conform with the federal statute. In each of these state statutes, these states adopted the militia age of 18 and required militiamen to arm themselves. So here you have Judge Kleeh relying on other cases, other history, and the Militia Act itself from 1792 to point out, obviously, how on earth can you find a historical analog law that prevents 18 to 20-year-olds at the time of our founding from being able to acquire handguns and firearms? It simply doesn't exist. And if anything, again, the affirmative historical record of the laws on the books at the time shows just the reverse, that 18 to 20-year-olds actually had an affirmative right, in addition to everyone else, to acquire firearms because they had an obligation to do so as part of their militia musters. And of course, as you know, the way it works is that people own these commonly owned firearms, these commonly owned weapons in their homes for their own personal private uses.
And when the militia muster was called together and people had a muster as part of the militia, they would bring their own firearms that they had in their day-to-day lives with them to militia musters. Now, they didn't have to bring all their guns or all their ammo or all their black powder or anything like that, but they had to bring some of it with them. So if they had 20 guns at home, they didn't have to bring all 20 guns. They just had to bring one working rifle or one working gun with them, the militia musters. That was the obligation. So again, major win today here. I've been predicting that in next term, the 2024-2025 U.S. Supreme Court term, this issue involving the gun control laws that prevent 18 to 20-year-olds from being able to acquire handguns from FFLs, this law will get struck down by the U.S. Supreme Court. I think it's pretty clear where this is all going. And Judge Kleeh in the Northern District of West Virginia is adding another nail into this coffin, but ultimately it will be the U.S. Supreme Court that whacks this law and buries it for good. Okay? All right, folks, hope you learned a little bit something here today. Exciting news. This will be used around the country. Let's keep our fingers crossed. The good news keeps coming in, and we will talk to you soon. Don't forget to follow me on X at 4 Boxes Diner, and share and like this video, and we will see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.